Hi, everyone. Welcome to our Hot Topics lecture series. It's great to see you back here and some fresh faces as well. I'm Melissa Scanlon. I'm the, yes? You're, I'm Melissa Scanlon. I'm the director of the Environmental Law Center. There's a gentleman in the back requesting poetry at the beginning of the sessions. Sorry, I don't have one for you today. This is a brown bag lunch series, and please hold your questions until the end. We'll have a lecture followed by a Q&A where you can engage with our speaker. So today I'm pleased to introduce Sean Donahue. He's a partner at a law firm called Donahue and Goldberg. He is a 1992 graduate of University of Chicago Law School, and he decided to take it easy after law school. And he went to clerk for Ruth Bader Ginsburg, and then he went on to clerk for Justice John Paul Stevens. After that, he was practicing law with Jenner & Block's Washington office, and then he spent 4 years practicing in the appellate section of the Justice Department's Environmental and Natural Resources Division. Since he established his own appellate practice in 2002, Sean has participated in several significant cases before the U.S. Supreme Court, including successfully briefing and arguing environmental defense versus Duke Energy Corporation for the petitioners and representing environmental organizations in major Clean Air Act cases in the Supreme Court's 2013 and 2014 terms. Sean has taught environmental law at several law schools throughout the country, and in recent years he has coordinated environmental groups' participation in Clean Air Act and climate litigation, including the pending DC Circuit litigation over the Clean Power Plan, which is the subject of his talk today. So today he's going to be presenting the Clean Power Plan in courts. Please join me in welcoming Sean Donahue.
Thank you very much, and it is wonderful to be here in this lovely place. My mom and my daughter are in the back row, and my mom lives in Plainfield, New Hampshire, so it is a special treat to come to this part of the world, especially at this time of year. I thought I would divide my talk into 3 short pieces. It's going to be mostly descriptive, sort of what is the Clean Power Plan, where did it come from, where does the litigation stand, and then I'm going to do my best to preserve time for question and answer because this is a massive topic. There's a lot of complexity to the regulations, to the legal framework, and I know that some of the audience is better situated to give this talk than I am and will know most of what I'm going to say, and other people it's going to be new, so I'm going to try to kind of say enough to confuse everyone equally, and so everyone will have some questions. Okay, and I think, climate change, the science is ever more compelling. The levels of greenhouse gas emissions in the atmosphere are remorselessly moving up. We are seeing impacts that are more and more graphic and alarming. People have been obviously talking about this problem and what to do about it for some decades now, and including a lot of debate about whether this year at the top, very hot so far. A lot of debate about whether the answer, at least domestically, is a big nationwide program to address greenhouse gas pollution comprehensively, or whether we can even do that politically, and if we can't, or if we don't think that's a good idea, what can we do under existing law, notably the Clean Air Act. And when we talk about using the Clean Air Act to address climate change, it's important to note that the Clean Air Act is not sort of one simple thing. It is a complicated set of provisions and programs put together over at different periods of time. And so there are a lot of different mechanisms, many of which could speak to different aspects of greenhouse gas pollution or the climate change problem. And so I just want to very briefly, and this will be old news to most people, but just very, very briefly run through some of the different programs that that are found in the Clean Air Act and that might potentially be relevant and that will come up later. The National Ambient Air Quality Standards, health-based standards for common pollutants like soot, particulate matter, enforced through state plans with the goal of meeting a safe level of particular pollutants in the air throughout the country. Sort of the core of the Clean Air Act, the NAAQS program. And then in addition to that, and this will loom large for the Clean Power Plan, there are provisions addressing or imposing technology-based pollution control standards for stationary sources, factories, and there the direction to EPA is kind of regulate in a way that is technologically feasible and reasonable from the perspective of cost, and that's section 111, which is titled New Source Performance Standards, and we'll talk more about that. There is a special program for so-called hazardous air pollutants, which we often think of as sort of toxic, carcinogenic, acutely harmful, although the legal definition is a little less precise. There's a provision on international air pollution. There are actually multiple provisions. One of the most prominent is section 115, which gets a lot of discussion as a possible remedy for the climate problem. There are permitting programs for any big new stationary source. You have to get a permit under the so-called prevention of significant deterioration or non-attainment programs that covers pollutants from your new source. And there are standards for mobile sources, for cars and trucks. So all of these different things. So we can argue about whether the Clean Air Act makes sense as applied to greenhouse gas pollution, and then there's a more sort of granular argument about if we've accepted that the Clean Air Act applies, how does it apply and what particular provisions are applicable. A very, very brief rundown of this several decade-long debate about the Clean Air Act's role as a tool for addressing climate change. The then General Counsel of EPA, almost 20 years ago in 1998, issued a memorandum saying carbon dioxide satisfies the statutory definition of air pollutant, and I conclude that as a legal matter, EPA has the authority to address greenhouse gas emissions under the Clean Air Act. The Clinton administration did not produce any actual regulations, but the position was there that the power was in place in the act, at least to do some things about it. A petition for rulemaking was filed by environmental groups saying to EPA, okay, let's get on with it. And in 2003, the Bush administration concluded that the earlier position was wrong, and that in fact it just didn't make sense, and that carbon dioxide is so different from the kinds of pollutants we've classically regulated that it doesn't belong under the Clean Air Act. It's not a pollutant, and it's otherwise unwise to use the act. And that was what led to the epical Massachusetts decision in 2007, where a divided Supreme Court by 5-4 votes said, looking at this broad statutory definition, looking at the compelling evidence that carbon dioxide is causing serious environmental and health problems and risks, we think the statute applies. And so you can't deny that. Maybe you can get away with not regulating if you have a good reason based in the statute, and send it back to EPA. The Bush administration then produced a lengthy document sort of examining, and it's widely portrayed as a sort of foot-dragging exercise, that it was, rather than actually regulate, we'll talk about regulating, but they produced this long analysis called the ANPR, the Advanced Notice of Proposed Rulemaking, that looked at lots of different provisions and discussed how they might be useful against the diverse and complicated sources of greenhouse gas pollution. After Obama's election, he had, of course, campaigned on a promise to do something about greenhouse gases, both legislatively and under existing law. And his EPA, at the end of his first year, issues an endangerment finding under Section 202 of the Act, which happens to be the provision dealing with moving source motor vehicles. But the test under many provisions is the same. Does this form of pollution endanger public health or welfare? And that document was sort of an overview of the science, and the answer was clearly yes. And that meant that EPA was obligated to promulgate standards for cars, which it did, which then led to this huge initial round of litigation in the DC Circuit, which resulted in a case called Coalition for Responsible Regulation, upholding the Obama administration's efforts, which included both this fairly ambitious program for cars and an effort to accommodate some of the ways in which the Clean Air Act is difficult for greenhouse gases. In particular, I briefly mentioned the permitting programs for big stationary sources, new factories. It turns out that the pollution tonnages mentioned in the act that Congress sort of thought would identify big sources of pollution based on how many tons per year of emissions, as applied to carbon dioxide, sweeps in much smaller sources, even restaurants, small apartment buildings. And EPA faced this problem. Are we going to start regulating them the way we regulate factories and require permits? EPA tried administratively to sort of exempt them, and the Supreme Court, the DC Circuit upheld everything that EPA did. The Supreme Court fairly harshly castigated EPA for sort of trying to bend the law, and the court, in a decision that can itself certainly be characterized as bending the law, but said the better thing to do would have been to say greenhouse gases are not a pollutant for this purpose, for purposes of this program. So that case, the UARG case, might be regarded, and that aspect of it was 5-4 with the more conservative, the sort of familiar breakdown, might be regarded as a little bit of a half step back from Massachusetts. And the court is wondering, does it really make sense, at least always, to go after greenhouse gases? On the other hand, it might be a warrant for EPA to go about regulating in a way that EPA thinks is well tailored to greenhouse gases. So that's basically where things stand on the eve, or sort of the setup for addressing the single biggest source of greenhouse gas emissions in the United States, which are power plants, fossil fuel burning power plants, which is coal and natural gas mostly. So in addition to being the biggest, some of the other features that are relevant to the regulatory problem are that the generation mix is extremely different. For example, the West Coast states, Washington through California, almost no coal generation, not a ton of gas relative to other parts of the country, a lot of hydro, but virtually no coal, whereas the Ohio River Valley, the Southeast, Texas, very heavily reliant on coal generation for almost all their electricity historically. It's changing a little bit. So that is a complicated problem for any kind of regulation. Another curious thing about this set of sources, unlike factories that make widgets, power plants are all connected to each other through the grid, and the people who operate the power grid are constantly kind of calling on one or another, and the supply of electricity is kind of determined by demand, and it has to be perfectly balanced all the time. So there's this way in which different producers are interconnected and related more tightly than is the case for many other kinds of industrial activity. And another thing that's noteworthy about this sector is massive change already ongoing before EPA got into the business of regulating greenhouse gas or CO2 from power plants. Natural gas prices have dropped a lot, making natural gas much more attractive relative to coal. And natural gas generation has been displacing coal. And then also, of course, famously, rapid growth in renewable generation, also driven in large part by a drop in cost. So this slide just shows for 2014. On the left, you see new capacity, and it is sort of divided between natural gas and renewables, and virtually no new coal. And then on the pie chart on the upper right, you have retirements with coal constituting the largest share. And that sort of dynamic has been seen for a number of years, basically the last decade plus. So now we're moving to the second. That was all background. We're now going to talk about the Clean Power Plan and sort of the legal basis. I briefly mentioned Section 111, titled New Source Performance Standards. It's sort of calls upon EPA to set emissions limits for stationary sources of various pollutants. Many of them are big factories, but there are new source performance standards for wood stoves as well. Good trivia point. And it's, most people think of Section 111 as addressing new sources only, and that's what the title would suggest. But there is also this provision 111D, which is addresses existing sources of pollution and establishes a program that is kind of unique. It is unlike the standards for new sources, where EPA just prescribes limits that the sources have to comply with. The existing source regime is based on a state implementation model where EPA sort of sets minimum standards, and then states come up with plans establishing performance standards for the existing sources within their borders. So it's a cooperative federalism regime. I have quoted this language not because we have time or I'm going to force you to engage in sort of tedious parsing of statutory text, but the language here is vital to the legal disputes in the case. The bolded language is from the definition of standard of performance in Section 111, and it prescribes the criteria that EPA is to use in sort of setting pollution limits under Section 111. And so let's just look at, EPA is supposed to identify the best system of emission reduction, which happens to be abbreviated often as BSER, which has been adequately demonstrated. Another key idea, EPA is to look out there and figure out what is observed in the relevant source category. What are people doing to reduce emissions? And then the EPA is also supposed to consider cost, among other factors. So that's an EPA determination of sort of what's the best system for reducing pollution from this source category. Okay, so for power plants, EPA actually had to do two rulemakings because Section 111 says that you can only regulate existing sources in a given category if you've already regulated new sources. So EPA did this tandem rulemaking where it promulgated standards for new power plants and a separate rulemaking, which is what is generally referred to as the Clean Power Plan, which covers existing sources, which is the one that achieves more emissions reductions and has garnered more interest and is more controversial because of the general idea that asking existing sources to change their ways is sort of more difficult or more legally complex than simply prescribing standards for new sources. So EPA conducted an almost unprecedentedly large rulemaking, lots of outreach, massive millions of comments, lots of input from all kinds of stakeholders, states, regulated entities, NGOs, et cetera, more than the usual big rulemaking, to determine what is a sensible way to set standards for existing power plants that account for so much of our greenhouse gas emissions, but are so absolutely vital to our economy, our daily life. At the same time, And in the final rule, EPA came up with a sort of combination of measures that EPA determined, applying these statutory factors like cost, should be deemed the best system of reducing emissions from existing power plants. And there are three elements. One is efficiency upgrades or heat rate improvements, basically making the power plant deliver more output per unit of fuel. And that can be done by upgrading equipment, getting a new turbine that works better and wastes less. And EPA found that that can achieve at least some emission reductions, probably less overall than the other two I'm about to mention. The second one is shifting power generation away from coal plants, which emit about twice as much as natural gas plants, shifting from existing coal plants to existing natural gas plants. So turn off the coal plant, turn up the natural gas plant, and you're getting the same amount of electricity but less pollution because the gas plant is emitting less. So that's a second way EPA found that you can reduce emissions from this source category. And then the third is reducing generation from fossil plants, both coal and natural gas, and increasing generation from new renewable sources like wind and solar. And EPA said all three of these so-called building blocks, these sort of techniques for reducing emissions, are already in widespread use in the industry. They have been facilitated and furthered and used to comply with state programs like the RGGI program in the Northeast and California's greenhouse gas regulatory regime. And EPA said these are also the most cost-effective way to get there. EPA thought about other ways that you can reduce emissions. Some of them include changing coal plants to gas plants, at least in part, so-called co-firing of a coal plant with gas. So the gas produces less greenhouse gas emissions. You're going to generate part of your electricity from the former coal plant with gas. And that's done in the industry for economic reasons already. EPA said you can comply with the Clean Power Plan that way, but we don't think it's as cost effective as this combination of building blocks that we've selected. They also considered capturing sequestration, carbon capture and sequestration, that is separating the CO2 from the exhaust, or separating it from somehow from somewhere in the production process, taking it out and preventing it from going up into the air. EPA said maybe some people will comply with that and that would be allowed, but it's pretty expensive for existing plants and we don't think it's the BSER, the best system. And EPA also took a very hard look at demand-side energy efficiency. That is programs where, as many of you I'm sure are well aware, that people sort of encourage and aggregate reductions in demand as a way of reducing pollution. And EPA said that too, that's a very cheap way of reducing pollution, and it's already in widespread use, but EPA decided, essentially because they thought it was a close call legally, whether it was permissible under the statute, they omitted it from their definition while allowing people to comply with it. So I've several times said EPA included something in the so-called best system, and other times they excluded it but said you can use it to comply. And this is, I think, a critical thing for the matters in dispute in the case. All this is EPA setting an emissions target. So the best system of emission reduction is EPA looking at what's been demonstrated and what's cost effective and saying, we think this is sort of makes sense as the best system, but it won't always be the best for everyone. And we're simply going to turn this into a number, a set of emission performance rates, one for coal and one for gas. And we're going to set that number, and we're going to tell states, we want you to meet this number on average, but we're not going to tell you how you're going to get there precisely. And there's a ton of discretion for states to use different things, including demand-side energy efficiency. Or if a state says, we think we want to, preserve more coal, there are ways they can kind of adjust their program. They could even require carbon capture from existing sources if that was a priority for them. So the best system is just about determining the stringency of the pollution control targets. It is not a mandate that either states or industry use this particular combination of measures. It's a way of getting to the target. A few things one might say. What the Clean Power Plan essentially is are these guidelines, an emission guideline for states, and a lot of rules about how states should design their plans to achieve this emission reduction goal. But it depends on states adopting their own plans, and much like the state implementation plan process for NAAQS pollutants. So there's there's a complex process where the states will come in with plans, and EPA set out a timeline for that, which required states to submit their plans no later than late in 2018. This whole program doesn't begin to actually apply or require emissions reductions until 2022. So there's a very long lead-in period, which was considered necessary to allow for the substantial amount of state planning and sort of industry planning to achieve compliance. And then even in 2022, it ramps up gradually, and final compliance year is 2030. So this is a very long window. The other things one might mention, the EPA really emphasizes that the BSER that it came up with is based on trends that are already in evidence in the industry. It's not requiring something completely new. And EPA also says our program here is based on the special characteristics of the power industry, including interconnectedness. Because what I described in building blocks 2 and 3 about shifting generation from a coal plant to a gas plant, or from a gas plant to a solar farm, that has been characterized as extremely unusual. You're actually telling one party to stop producing so that its competitor can produce. That's the argument, and that's the kind of thing that the challengers have latched onto in the case. And EPA says, actually, in this sector, this makes a ton of sense because everything is already interconnected. The grid operator is already constantly making these choices among sources based on cost and environmental considerations, and so you have an industry where shifting of generation as a means of achieving environmental compliance is already routine, and also many of the companies actually own lots of different kinds of generation, from coal to gas to renewables, and they within their own internal fleets already engage in these kinds of shifts. And the Clean Power Plan is very much based on the expectation that emissions trading will be the sort of lifeblood of state plans, and with the opportunity for interstate trading, which EPA found would be the cheapest way to comply. Doesn't require that, but based on EPA's experience with other programs, that's the expectation. Now let's talk about the litigation. The day that the Clean Power Plan was promulgated in October of 2015, even before that day, actually, there were lawsuits filed challenging the proposed Clean Power Plan, which is, as you know from administrative law class, not something you can normally do. And the DC Circuit decided it's not something you could do in this case either. But there was such a level of intense feeling about it. It's basically another of these now familiar major initiatives that this administration has undertaken. Think Obamacare and the immigration action that divides the country very much along the sort of familiar red-blue lines. It's not perfectly matched, but basically you have 27 states, pretty much all of them with Republican governors and or AGs who have the authority to commence the litigation, challenging this in very, very stark, very harsh terms. This is usurpation. This is a power grab. This is totally unprecedented. This will cause blackouts. This will crush our economy. very, very strong terms, and also very, very intense opposition from the coal industry, which is sees this as the most direct of several attacks on it. And on the other hand, very, very fervent support from a lot of other states, including a lot of the northeastern states, led by New York and Massachusetts, California, and many other states have intervened to support this. Quite a number of power companies are supporting it, saying this is reasonable, this is how we are moving, this is the direction we're moving on. Carbon constraints are coming, and we just need to know what the rules are, because uncertainty is really hurting us. And then also, perhaps unsurprisingly, a lot of environmental and health groups, and then a massive array of amici on both sides. I think I'm very proud of the amici on our side of the case, because we have a really big array of everyone from big tech companies, a lot of members of Congress, and a lot of really great sort of technical expert amici and climate science and health science. Anyway, a massive array of contesting forces in this case, even compared to the usual big DC Circuit rulemaking case. So just quickly, what's happened in the case, the parties challenging the rule immediately moved to stay it, to block it, pending judicial review. There was a massive litigation over that with a lot of factual filings about irreparable harm. Would this cause harm in the near term, particularly given the protracted schedule? The DC Circuit, after considering all that, unanimously denied the stay. A few days later, the parties filed a very unusual stay motions with the Supreme Court. The general view was this is probably going to be denied, because the court has never granted a stay in a circumstance like this before any lower court has reached the merits. But there was expedited briefing, and to the shock of everyone, I think on both sides, the court by a 5-4 vote granted a stay pending either and the stay doesn't end when the DC Circuit reaches the merits. It stays alive until either the Supreme Court denies review of the ultimate DC Circuit decision, or the Supreme Court itself issues a decision on the merits. So very surprising, regarded as a dangerous sign for the program. A few days, 6 days or something after the stay, Justice Scalia passed away. Another shock to everyone, but obviously also a potentially significant event for the Clean Power Plan's prospects in the Supreme Court. And then there's one more big litigation surprise as we were getting ready for oral argument and starting to have moot courts and stuff. All of a sudden, an order comes out from the court saying, oh, by the way, we're going to hear this case en banc with the whole complement of active judges instead of before a 3-judge panel. Extremely unusual, almost never done, and you could say the times it has been done are kind of not analogous. So I assume that had something to do with the court understanding this is definitely going to the Supreme Court based on the court's action, and so we might as well kind of jump to the en banc phase. But another surprise. So we're all kind of all of us in the business of providing learned advice about what is going to happen and what courts will do have been, much like political commentators this year, given a healthy reminder that we often have no clue. So here, there are many issues in the case, many, and some of them very familiar. Administrative law. Does the record support this determination about how much renewable energy capacity is available in this region that went into EPA's BSER determination and resulting pollution control targets? Questions like that. And there are questions, did EPA provide adequate notice of this issue in the rulemaking so that people could comment, and plenty of issues like that. But I've separated out the 3 that I think are the sort of really big ones. And I think the first one, I think almost everyone would agree, is the big one, and it's the so-called fence line issue. That is with respect to the second 2 building blocks that contemplate reducing emissions by reducing generation, the operation of some power plants, in favor of other power plants that are going to produce sort of compensatory electricity that produce less pollution. Is that legal? Does the statute allow that, or does it simply contemplate putting some kind of control on the end of your smokestack, or requiring that you use this or that device on premises to reduce pollution? Does it allow consideration of emission reductions that are only available by considering off-site activities like increased use of renewable generation that will displace relatively dirty generation? The petitioners say the statute doesn't allow this, and nothing like this has ever been done. So that, I would say, is the central issue, and certainly what they would say in Candid Moments is their number one issue. I will briefly describe the second issue, which is a somewhat more radical proposition that EPA doesn't have authority to regulate greenhouse or CO2 emissions from power plants at all, because EPA has chosen to regulate hazardous air pollutants like mercury from power plants, which EPA did in a 2012 rule called, another big controversial Obama rule that has had some Supreme Court experience, called the Mercury and Air Toxic Standards. The reason, so it might seem odd to say, if you decided to regulate mercury, which we worry about because it damages human health and ecosystems through bioaccumulation and interfering with nervous systems and that sort of thing, that's a different thing than CO2 and the way it harms us, and why would you require EPA to kind of pick between the two? The argument is that the text of the statute compels that result, and I've been choosing to not get into this. It's an interesting issue. I think it's ultimately a losing issue for the petitioners, but they say that the highlighted language essentially says you can't use this 111D existing source mechanism when you're talking about a source category that is regulated for hazardous pollutants, even though the hazardous pollutants are not regulated under 111D at all. So that's their second issue, and that was an issue that the state of West Virginia and other sort of leading parties really pushed in that early pre-finalization challenge, and they still do to some extent. Okay, and then the final issue is a set of federalism-related issues that say, yes, this looks sort of like cooperative federalism like we have for ordinary state implementation plans to control particulate matter and sulfur dioxide, and that we're all familiar with, but actually it's much more far-reaching because it deals in this like fundamental way with the power system and with states' traditional authority to sort of choose their generation mix. And states are really compelled, while nominally under this program, like other cooperative federalism programs, a state can say, no thanks, for whatever reason, we don't choose to implement your rule. And then what happens is the federal government comes in, and EPA would come in with a federal plan for a particular state, and that has happened under other programs. But the petitioners, the states say, this is different because it gets into matters of state discretion and traditional authority that are quite unlike anything that's been done before. And those are accompanied with very extreme language about imposition on states, I think generally regarded as not their strongest. I think commentators on both sides would say that the ranking of issues here is probably the ranking of the strength of the leading issues. I talked about that, and now I think, so we have oral argument before an en banc court at the end of September, a massive array of characters, very big coalition of petitioners. They're going to have, if things go the way we thought they were going to go before the panel, they're probably going to have like 8 or 9 different attorneys, some for states, some for industry, arguing different parts of the case. Same on our side of the case, although obviously Justice Department will do most of it. The court hasn't issued an order about exactly what the argument's going to look like, but it will probably be a very extraordinary, 6 or 7 or 8 hour argument. So with that, I think I'd like to see measure the different types of confusion that I've sowed and ask for questions. Bob, I'm sorry. No, sorry. Go ahead.
He's from Maryland.
Yeah, no, I'm sorry.
Thank you. Wonderful, very clear, very comprehensive, and incredibly clear. Can you describe a little more your role in this litigation, who you're representing?
Yeah, so I represent the Environmental Defense Fund, which I've done for 10 years or so. Often, a lot of my time, but I'm outside counsel. And as in a lot of these prior cases, like the Coalition for Responsible Regulation UR case, I represent them. I work with an EDF in-house team, but I also kind of coordinate. So NRDC, Sierra Club, Clean Air Task Force, and a bunch of other regional and local groups are parties in the case too. So we have a big group of lawyers, and we kind of work together. And I think I'm the only sort of non-affiliated. There aren't many people who are sort of outside counsel. So it's partly that, and partly that I know everyone. I've been working with these folks for a long time. I sort of coordinate. So I'm not Sierra Club's lawyer, but I am treated as kind of the coordinating lawyer, and I will, if I argue the case, I will be on behalf of all the NGOs. So that's. Sorry,
they said the original
Bob.
For June, they reserved an entire day and then sort of set aside the next day in case it went over. How long do you think the arguments would take?
Well, it's not clear. They never clarified whether they were gonna. They said, counsel should reserve that second day of June 4th in case it goes over. And with the en banc court, obviously the costs of keeping everyone there are greater, and no idea. I mean, there were competing proposals. The petitioners wanted a little more time, but it wasn't dramatic. It was maybe another 2 hours, hour and a half of time. The en banc court could do whatever it wants. My guess is it will do something that isn't that far away from what the parties suggested. It hasn't called for a new round of argument formats yet, and I think it may just work from what we were going to do before the panel. But yes, I know. Well, in this Premature case, yes, I argued a little piece of that, and yeah, Lawrence Tribe, who's representing Peabody Energy, argued for like 45 minutes, like 1,600% over his allocated time or something. And I think it was partly because it was entertaining, because it was very bombastic. But I assume they will enforce it. And if Chief Judge Garland, who is kind of otherwise occupied at the moment, is recused or not participating, which we expect, but we don't know. But if he's not participating, then I'm not sure. Have to think about it. Would be Judge Henderson might be the senior judge and therefore presiding. And but my guess is when an argument is that long, they will have to enforce time a little more. Yes.
Hey, Sean, good job. With Garland presumably out, you got 10 active judges in the DC Circuit. Have you handicapped them? What does it look like?
I think the DC Circuit in these cases, I think they're obviously, like Judge Kavanaugh has expressed a lot of. He's been tough on EPA, and on the other hand, he's not. I think we're going in trying to get. Obviously, if we could get a lopsided win, that would mean a lot, right? In the Supreme Court fight that may follow. I think we have a good chance of winning the case in the DC Circuit. I think understanding that a lot of this stuff is difficult and complex and highly controversial, and that whenever you have credit to the other side, when you bring 27 states to the podium saying this is terrible, that has an effect on judges, right? That's a lot of, and I think that may have contributed to the Supreme Court stay. It's very unusual, but I think we're expecting very aggressive probing, questioning, but I think we think we ought to win. And that's my non-answer answer, but that's Pat. Yeah.
So you think EPA did a good job shrinking the elephant and enlarging the mousehole?
Yeah, I mean that's so. Pat is referring to a famous. I think he probably didn't invent it, but the phrase "you don't hide elephants in mouse holes," which is used in statutory construction for. You don't customarily find a sweeping power or incredibly consequential provision of law in a really obscure place. And the other side in this case has argued that Section 111D is itself a mouse hole because it hasn't been used very much. Unlike the new source provision, it's just kind of, and I think we say, wait a minute, it hasn't been used very much for various reasons, but it's not a mouse hole. This thing has it has a lot of words in it. It has some dignity in that it has the same structure as 110, the core provision, the state plan provision. This is not chopped liver, and you can't just excise it from the statute because you say it hasn't been used enough. So that's an awful lot of, more than most, I think most cases, people would say winning the case is not just debating points of law, but just getting the court to understand the facts or what is this about. And a lot of this case is fighting about sort of what is the Clean Power Plan? Is it radical? Does it build on things that EPA has done frequently? And that's a lot of what we've tried to argue, is that a lot of other rules, including the cross-state rule that the Supreme Court upheld, build on similar strategies and a similar understanding of how the power sector in particular works. And I think a lot of it comes down to whether that will be successful or not. Yes.
So again, from a handicapping point of view, I mean, you can imagine a scenario where there was no confirmation of Supreme justice for, another year.
Right.
Particularly if the Senate does not the win. In that kind of a scenario, you can imagine it would be 4-4, and so if you're correct, the circuit would uphold the rule. What would the court do at that point? Would they affirm it? Would they look to stay? Would they, try to hold it as long as they could? How do you think that's going to happen?
Right. I mean, and this has obviously come up with a lot of other high-profile cases, and there have been instances where the court may have denied cert, where they expect that there will be a 4-4. So the technical effect of a 4-4 ruling would, of course, be to affirm whatever the DC Circuit does. So it makes it important. It's not as if the DC Circuit proceedings are just this sort of warm-up act. It may determine the outcome if the court continues to be divided that way. And so you can imagine they would, even if they're 4-4, they might say, this is big enough, and we're hearing from a lot of states that say this is terrible, we should take it and try to, and at least ourselves decide if we're comfortable with it, even if there's a risk of a equal division. A lot of people expect that, if this case, as it will be, is argued in late September and we get a decision in the winter sometime, that it would be very hard for the case to be, almost impossible or difficult for the case to be argued in the at least regular 2016 term, that is, with the arguments ending in April of 2017 anyway. So you would be going for the next one, and maybe, but you're right, we don't know what this impasse is going to look like, and a 4-4 court is not at all out of the question. So that's just part of the unusual set of circumstances we face here.
How much of the argument can you get?
In the initial, do you mean me?
Yes.
Yeah. In the initial one, our proposal was for like 4 minutes or 3 minutes, which I've done lots of, and it tends to be we have to count on the Justice Department to cede us time, and usually if you're an intervener, if they think you have something relevant or interesting to say, they let you go on for 5 to 10, and if they're really tired, they will keep you to your 3. And so there was as you would imagine, a great deal of thinking and working through, that as we proposed it before the panel, I was going to talk about that second issue, the crazy statutory exclusion issue. Obviously, the environmental groups care very deeply about every aspect of the case, but based on, we have great lawyers. For the New York AG's office lawyer is terrific, and the industry lawyer, this gentleman named Kevin Polenkars, who's out in San Francisco, is terrific and really knows the industry well, and could talk very fluently about sort of generation shifting and so forth. So we hope he has a chance to really be heard.
Well,
Yeah.
with that, we're going to need to end this so that we can get to their after.
Sure.
Thank you for being here.
Oh, thank you again for having me. Thanks.